Hi, everyone.
Good morning, everyone, and welcome to Chamber Talk. This is Sultan Hatoum from Abu Dhabi Chamber of Commerce and Industry, and I have with me today for the second time Ziad Salloum from Salloum Partners to talk about a very controversial topic, force majeure in the context of COVID-19. We have hosted Ziad earlier in our third session of the program on a very successful event with more than 500 attendees, where he discussed how impacted businesses from COVID can manage employment relationships under the UAE law. Before I start today's session, allow me to first start by congratulating ourselves and the whole UAE community, from officials at all levels to citizens and expats, on the new ministerial structure that has been announced last week and approved yesterday. The new government reflects the wise vision of the UAE leadership as we enter into a new era of dynamic challenges and changing priorities. Several new ministries were established to cater for the new global development. This included the appointment of Minister of Industry and Advanced Technology, Minister of State for Digital Economy, Artificial Intelligence, and Remote Work Applications, as well as 3 ministers under the Ministry of Economy, with a specific clear focus on and dedication for entrepreneurship and SMEs. As we stand as the voice of the private sector, we look forward to working with the new government to elevate the competitiveness of the private sector and help in creating a diverse and knowledge-based economy. Our best wishes for the new government team in fulfilling the ambitions of the Emirati people and in preparing the country for the next 50 years of development march, as stated by His Highness Sheikh Hamad bin Rashid. After successful completion of 10 sessions of the program over the last 5 weeks, Chamber Talk has managed to attract more than 3,000 audience from more than 20 countries. We are continuing with the same power and support, with 12 more sessions to go until the end of the program by end of August. We hope you're benefiting from our discussion and leveraging the knowledge and insights provided by our expert speakers. I would like to remind you that all of Chamber Talk webinars are recorded and can be watched again on our Facebook page and YouTube channel. You can also watch this session in Arabic by visiting the link that the team will share in the chat box. We are also live streaming this session on Facebook and just started last week as well on Instagram. Shall you wish to attend the session on a different platform? We look forward for your engagement with us by submitting your questions in the Q&A box, and Ziad will try to answer as many as possible of it in the last 10 or 15 minutes of the session, depending how we're going with the presentation. So going back to our topic, the majority, if not all, executed contracts between parties contain a force majeure clause, but none of us have thought or anticipated that it might be discussed and negotiated at a very broad scale before being hit by the pandemic. Probably very few of us, except lawyers, I guess, have put much efforts in properly designing and drafting the details of this clause, not to say even reading or going through it at the first instance. It is what it is, and here we are now, in the midst of a global disruption that have triggered a wide debate around the viability, legality, and feasibility of applying force majeure clauses in all types of contractual agreements. As you might have noticed in the agenda for today's session, Ziad will try to shed some light on various aspects of the controversial topic, starting by defining what is force majeure and why is it important, and moving into discussing many other related concerns, such as what are the consequences of force majeure on affected contracts, what are the legal requirements for something to be considered a force majeure event, and what is the difference between contracts entered into prior to the pandemic and those entered into now. And he will end by addressing what steps can a party take to mitigate its legal and contractual risk, both with respect to contracts entered into prior to the pandemic and going forward. From this perspective, we are proud at the Chamber to have established the Abu Dhabi Commercial Conciliation and Arbitration Center, the first of its kind in the GCC and the region, who has been protecting members from costly and long proceedings brought by commercial disputes since 1993. The center acts as an alternative judicial podium that simulates the best international practices within the framework of privacy and confidentiality. Finally, whether COVID is considered a force majeure event or not, the question remains if you really want to activate this course of action. Despite of the short-term adverse impact resulted by liquidity pressures and disruptions to conducting business as usual, especially in such turbulent times, it is critical to assess the various angles of your options for the way forward, especially towards the potential adverse impacts on your credibility, long-term business relationships, and cost-benefit outcome from canceling existing contracts. Without any further delay, a brief introduction about Ziad before I pass it to him. Ziad is scheduled to be with us for 4 weeks. So for those of you who will be attending all the sessions, expect some repetition in the introduction. So Ziad is a second generation family business member and a partner at Salloum Partners, a boutique law firm which was founded 4 decades ago in 1980 by his father, Mr. Samir Salloum. Mr. Samir has received more than 24 international recognition awards for his distinguished services and civil achievements, mainly from Italy, Spain, France, Belgium, and Vatican, to name a few. And lately, has been awarded by the Embassy of the Republic of Lebanon in recognition of over 40 years of dedicated and distinguished services and contributions to the business community in the UAE. As they say, like father, like son, Ziad has also in turn received a number of international, governmental, and other awards for his distinguished services and achievements, notably from the Sorbonne University and the Vatican. And most recently in 2018, was named the leading employment law attorney of the year by Acquisition International. The firm itself has also received a number of prestigious awards and recognition, which is a long list to go. I'm going so fast because I want Ziad to embark on this presentation. It's going to be a lengthy one and very interesting one. Hope you enjoy it. Ziad, all yours.
Thanks very much, Sultan, for this fantastic introduction. And thank you all for joining us this morning. I hope that today's discussion will be interesting to you. So let's see if we can actually move to the next slide here. There you go. Yeah, so this is us. We've been here, like Sultan said, since 1980. So this year we should have been celebrating 40 years with a big party and stuff, but obviously that's not going to be happening. So yeah, but watch this space. We're, once all this dies down, we're going to get started and do something interesting. So we are a corporate commercial practice that's been here for, well, we've been working with government departments, local and international companies for quite a long time. So a lot of what we're going to be talking about today kind of is born from the interests of all the different clients that we are working with at this point in time. So obviously what we're going over today, or what we're experiencing, all of us around the world, is basically probably among the most trying times in living memory, and certainly among the most interesting. It's bringing up a lot of challenges for lawyers, for businesses, for governments around the world. And one of the big issues or concerns that the business community has that have come to mind as a result of the increasing costs, the decreasing capital, the uncertainty that's surrounding all of this, is obviously whether or not people can exit commercial contracts relying on force majeure as something to help them do that. So for most people, they've never really looked at the force majeure clause. It's usually something that they let the lawyers put into their contracts and never really read probably until now. Now, a lot of contracts do contain force majeure clauses. We're going to be talking about whether it makes a difference if you mention pandemic or government restriction or similar provisions within your force majeure clause. At this point, my personal view is it doesn't necessarily matter, and we'll understand more as we go down. Now, just a quick pointer, because there is a lot to cover, and the majority of the questions that we're going to try and cover are the ones set out here in front of you. This is intended to be a very broad strokes examination of the topic. There's a lot of detail that we could go into if we had maybe a couple of days, but we only have 40 minutes or so. So I'm going to try and be as informative as I possibly can, while being as brief as I possibly can. It means that to a greater or lesser extent, I'm not going to be reading everything that's on the page, because, I mean, what's the point? I mean, I'm going to try and explain a lot of the extras, the stuff on the outside, and hopefully illustrate some of the concepts that you're going to see on the page. And I'll try and move as quickly as I possibly can and make this as interesting as possible. So the first question that we need to ask is, what on earth is force majeure? So UAE law doesn't really have a definition for it. You will find that definition comes in jurisprudence, however, and it's basically those four things out there. So it has to be unforeseen and unforeseeable at the time of entry into the contract. So that's at the very beginning of the exercise when the two people are sitting at the table and shaking hands or whatever. It has to be something that the parties cannot prevent. It has to be something that's not related to the parties themselves. So you can't say, oh, hey, the bank failed to finance me and therefore this is a force majeure event. That's not quite how it works, right? It has to be something completely foreign, alien to you. And it has to make the performance of an obligation impossible, whether permanently, partially, or temporarily. And it's that word that's key, impossibility. And that brings us to basically what the consequences are of force majeure. And we'll find those in Article 273 of the Civil Code in the UAE. Now that is split into two parts. So 273.1 and 273.2. 273.1 deals with impossibility. And it states that if there's a force majeure event that makes it impossible to continue the contract for one party to perform their obligations, then the contract is automatically canceled. If under 273.2, if it's partially impossible, so only a portion of the contract cannot be completed, or it's temporarily impossible, like basically the airlines are basically, you cannot fly or you cannot ship your goods, but that's only for a short period of time, unknown perhaps, but it's for a period of time. And at some point, those restrictions are going to be lifted. So it's a temporary impossibility. So that allows for a party to, at their option, decide to cancel the contract. It's not an automatic termination like it would be if it was completely impossible to proceed. Now, I keep harping on about this issue of impossibility. Impossibility is key. It has to be actually impossible, not that there's another way around it to complete the performance. It's not enough that the obligation has become extremely costly or extremely burdensome for a party to say, oh, hold up their hands and go, I'm sorry, I can't do this. It's impossible. That I'm going to give you some illustrative examples as we go down the road. So I'm not going to kind of jump on that right now, but I have to stress this idea that it is impossibility that's at stake. And obviously, UAE jurisprudence has indicated that you must provide notice, even though that's not expressly stated in the article, at least not 273.1. There needs to be notice given in writing by one party to the other, especially by the party that wants to rely on force majeure as the reason for termination of the contract. Now, I'll give you a quick anecdote as to why this issue of impossibility is important. So earlier this year, in March of 2020, we were supposed to be holding the International Lawyers Network annual General Assembly and meeting here in Abu Dhabi. I've been pushing this for, I don't know, 9 to 10 years. Our firm has been a member of this group for about 12 to 14 years now. I forget exactly. I was a board member until this year. I ended my term after 6 years on the board, and I've been trying to convince people to come out to Abu Dhabi and see this extraordinary place. And I finally succeeded. And we were supposed to hold a meeting in March of 2020. Now, to give you some context, the ILN brings together some 95, 96 law firms in 65 countries, something like 6,000 lawyers in total. We were expecting to have pandemic hit. So, but at the time when we were still looking to either proceed or cancel, none of the directives of the government to kind of shut down the restaurants or hotels and whatnot had actually come into place. So we were still wondering what to do and whether we could proceed. Travel restrictions hadn't completely come into force. They had in some places. It was basically a gradual bit, and it was a gradual change over jurisdictions from one country to another. So we had numerous discussions internally within the board and the leadership of the ILN as to whether or not we could continue or not. Ultimately, it was found that even before the restrictions came down, that it would not be possible for us to continue from our point of view, because we wouldn't have enough people attend to make this a worthwhile exercise. We'd maybe have 10 to 20 people instead of the 200 we were expecting previously. So we looked at the contracts with the various hotels and venues for the events that we were holding, and they obviously contain a force majeure clause. So we had to, us lawyers, we dug into it, and this issue of impossibility was a real burden, because it wasn't actually impossible at that time for us to continue and proceed with this. We could have, it wouldn't have made sense because there's obviously not enough people and there would be a massive financial loss for the island, but that doesn't make it impossible. The event could still proceed. It doesn't matter if the hall is empty, the event it's possible to hold it. So we're all praying basically for the government to come down and shut down travel or something, so that, hey, we had something to stand on when we were discussing with the different venues. Now, some of the venues were extremely accommodating from the beginning, even before any restrictions came down, but a couple of the venues were less accommodating. So that's to give you an idea of this core item. This impossibility needs to be actual impossibility. And I will give you a couple of more examples as we go down this. So what are the consequences? Assuming you do manage to convince the courts or the other party that there is an event of force majeure, what are the consequences? It's essentially termination of your contract. And that is, you have to reinstate people into the position they were in at the outset. So if you're buying a mobile phone, let's say, and you paid the money in advance and the gentleman cannot deliver because of force majeure, well, he has to return the money to you, every cent that you have paid. But what about, so that's fairly straightforward enough, right? So what if a party has already executed some of the work? What do you do then? Because obviously you can't go back to the situation you were in at the beginning because, hey, some of the work has been done. So thankfully there is a principle in the civil code that kind of tackles this point. And this principle is illustrated in two articles, or more particularly Article 894 of the Civil Code. Now, these two articles that you can read up here, they deal mostly with contracting work, so muqawalat, construction sector and so on and so forth. But the general principle remains the same. If the person who plays no part, so the point is, so these two articles you'll see don't necessarily apply only to force majeure. They can apply to any other circumstance where termination has to occur because of a foreign event that is unrelated to the party in question. And there, the party in question is entitled to recover the full sum of the work that has been completed. And that will be up to the court to decide what the value of the work done is. So let's say you've only built half the building. Well, yeah, in principle, there's supposed to be some value that the person is going to derive from half a building. Conceptually, maybe for us, we can see, well, it's no use to me if the building's not completed. But still, he has a starting point. The person has a starting point from which he can carry on once all this is done and dusted, or if he can find somebody else to continue the work. So in principle, there is a value to the partial construction that's out there, and therefore they're entitled to part of the sum or some value for the work done. That doesn't stop people, obviously, from, because these articles don't apply only to force majeure, if there is an element of fault there, then obviously the party can also claim compensation for the loss suffered, whether it is expenses that they've incurred that has not yet translated into a net benefit to the party, or otherwise loss of profit and so on. We're not going to go into those details at this point in time because it's not relevant to our discussion. So these are some of the, well, what you're seeing up on the screen now here is some of the views that the courts have expressed across the UAE, well, in this particular example from Dubai, about for the application of force majeure and what happens. So it's a confirmation of what we've talked about previously, and it kind of puts it into the context of Articles 893 and 894 as well. So it's an illustration of what we were talking about earlier. So is there compensation payable? Well, I think we've just kind of tackled it here. There's no compensation payable in principle if there is a termination because of an event of force majeure, because this is an event that is foreign to the control or the power of either party, something they had no hand in in it and they were not able to prevent. So neither party is at fault to the other, and therefore there's no liability for one to pay to the other. And that's something you can see also in other articles of the law. So it's a general principle of law that there must be fault for there to be a consequence that you might be liable for something. So essentially, if you want in legal speak, the first bit is there must be a loss. The loss must have, the cause of the loss must be action or inaction of a person, for that person to be liable for that loss. So in the absence of that, if in the absence of the cause due to the individual or the company or whichever it is, then they should not be bound to make good the loss. And this is something you can see in this article of the law. So the key requirements here are obviously the loss must have arisen, the loss must arise for a cause outside of the control of the party, and then the party that is trying to rely on this concept, they must be able to prove that they are not responsible for that loss, that the loss is due to something else extraneous to them. Now, like we said, this article also is not only applicable to force majeure. There are going to be instances where a force majeure event does not occur, but an external event that is outside of the control of the parties does occur that may lead to the application of this. So that's why a lot of the concepts that we're going to be tackling from here on out are issues or articles of law that might apply in a force majeure event and may not apply as well, but they are general principles of law that apply in general. So again, the Union Supreme Court and so on and so forth. There is an issue of the standard of proof required, or the burden, how a person can discharge that burden and that standard. And as you're going to see as we go down the road, the standards required are extremely high, whether it is to prove that something was, well, if you want to prove that something was completely outside of your control, that might be a little bit easier than let's say, absolving yourself completely of responsibility under either force majeure or something else. And it's that concept of impossibility that is there. Now, if you tell me, so if you tell me, okay, so we can't establish impossibility, then what do we do? Then we're going to have to look at all the other alternatives. There must be, perhaps you can say, something else in the law that's going to allow us to protect us basically from liability in the event we're not able to perform our obligations under the contract because of this unforeseen events, COVID-19 pandemic, and so on and so forth. So what options do we have? Some of them we've discussed earlier, some of the non-exhaustive articles. This is just a few of them. There's also, for example, there's an article, and this is going to be interesting later. I haven't put it up here at this point in time, but I'm going to explain what it is. It's Article 794 of the Civil Code. Virtually all the articles I'm going to be talking about here, unless they've specifically mentioned, all relate to the Civil Code. So because we've already covered Article 893 and 894, we're going to skip over those, but we'll talk briefly about the other two. And I'm going to start with 472, because that one is fairly straightforward. So it's just basically one slide. So this talks about rights as opposed to a contractual obligation. So if your right expires, then because of something that's again an impossibility, then the right will just kind of disappear and you're not going to have any entitlement along that line. The more important item, or the more interesting article from my perspective at this point in time, is this article here, because this does not deal with impossibility. And it doesn't necessarily deal with force majeure, because of force majeure, basically an exceptional circumstance of a public nature and is independent of the party in question. So it's a very similar definition to force majeure, but it's not quite. It doesn't rise to the level of a force majeure event. It's still an exceptional event, and it causes the obligation to become extremely oppressive for the party that is supposed to be performing it. And that threatens them with grave loss if they were to actually execute. So the courts have the authority in that respect then to come in and reevaluate the contract and make it more balanced. So it lessens the burden on the party that needs to perform. So this provision requires that the circumstances must be of a public nature. So they have to be essentially something that's not really necessarily connected to the individual concerned or the party concerned. So I gave you earlier the example, and there's a court case, a judgment that kind of tackled this point, where a developer basically said, well, this is I need to apply Article 249 because the bank didn't finance me. The court did not deem that as a sufficient excuse. I mean, the party should have prepared themselves ahead of time and made sure that they had sufficient financing before they went into the project. That's as an aside. But in this particular instance, the court found that this was not a foreign item. It's not of a public nature. It's specific to that person, that particular party. So it's not like what we're going through now, for example, which is the general idea, right? COVID-19 and the mess that it's put a lot of people in is something of a public nature that is completely foreign to each specific individual. It's a general circumstance. And obviously it has to be something that is unforeseen. So it's a similar requirement as to what is required to define force majeure. It has to be something that was not foreseen at the time you entered into the contract. And as a result of this, it became overly burdensome. So can you then maybe justify revisiting your contract to make it more balanced because of COVID-19 if it doesn't rise up to the level of a force majeure event? I'm going to give you an example to illustrate how difficult it is to get out of stuff like this. So the standard you're going to see is going to be extremely high. It's a very high bar. Now, the commentary that I found in some of the books on law basically tell you that the standard that should be applied is by reference to the underlying contract. Unfortunately, there seems to be very little jurisprudence that in the UAE, at the very least, that kind of tackles this item very specifically and very directly, because the courts typically don't give you don't give you a full picture of why they reached a particular conclusion. It's enough that it's at their discretion to do so, and they do kind of give you a general idea, and they tell you that we established that it did not rise to the level of an oppressive obligation. But why? What did they use to choose to say that this particular thing did not rise to the standard, or this particular thing did rise to the standard? That one is basically above my pay grade at the very least at this point in time. So to give you this example here, so there was a cassation court judgment about a construction contract that related to a construction project in Abu Dhabi on the mainland, on the island of Abu Dhabi, in fact. So at one point, the main road was closed due to works. And this was not something that either of the parties had anticipated at the time. And essentially, access to the property in question was blocked with the exception of a tiny side road from the back. Now, the contractor claimed that the side road was far too narrow to allow him to bring in the equipment that he needed to be able to build, or at the very least that if they were going to use that side road, it was going to be extremely time consuming. It was going to require specialist equipment, and it was going to add a tremendous amount to his costs. So much so that it was going to be extremely oppressive. That's what he argued in front of the court. Now, the experts in the case identified, or in the report, they put in that the costs for this, to be able to bring in the material onto the site, was going to be somewhere in the range of 50 million dirhams. So yeah, it's not peanuts. The court, when they evaluated the case, they said, well, it's our discretion to either apply the expert report in full, or to extract the elements that we consider are valid and excise the rest, which is exactly what they did in this instance. They found that, well, the determination that was made by the expert that it would be too oppressive was incorrect. They found that the value of the contract was greater than 50 million, and therefore they didn't find that this was an oppressive burden for the contractor to bear, and therefore there was no increase in costs. So I'm sure a lot of the contractors maybe who are listening in, they know the margins on a project. So when you say, even if the value of a building or a construction project is 500 million, 50 million can be a massive hit to take. 10% is way above a lot of margins for many contractors. So you can imagine that, you know, you should, or you would, as a reasonable person, perhaps anticipate that this becomes an oppressive item. The courts don't see it that way. The court, so if we go by the tiny note in the commentary about, we look at it by reference to the contract value, that means that if it's, you know, you could in theory say, well, if it doesn't exceed the contract value or isn't substantially equivalent to the contract value, it's not oppressive. You're still bound by it. That means that essentially the bar is way, way high. It's not an easy thing. And this is perhaps something that is intentional because you clearly, it is not in the interest of anybody if you are able, or if parties are able to get out of the contractual obligations very easily. The idea is you enter into a contract, you are aware of the risks, you either put into, because every contract ultimately is an agreement to split risks. If you are buying something, you are agreeing to take the risk of damage or loss of the property after a certain point in time, let's say after collection, after you collect it. You could agree that the risk passes to you at the factory of the seller. You could agree that it will pass at the time it is loaded onto the ship, before the ship sets sails and comes over to you to deliver the goods to you. It is all about, every contract that you will ever enter into in your life is at its basic function and an agreement to split risks. So if you're a commercial party and you're going into a contract, you need to take your precautions, and we will discuss that in more detail down the line. So that brings us to this very, very central question, which is on everybody's mind. So, well, is COVID-19 a force majeure event? My personal view is, at least the short answer, it's not likely to be, at least not on its own, because it's not the pandemic itself that is the force majeure event. It's going to be the consequences of it. So either, let's say, the decisions that a government has had to take in order to protect its population. So they had to shut down hotels, they had to shut down travel, they had to shut down, you know, cut off access of Abu Dhabi to Dubai in certain aspects, and so on and so forth. So those decisions, the precautionary measures, do they rise to the level of a force majeure event? That is perhaps the more detailed answer that we need to focus on. And for that, we're going to have to look at the first three items at the top of this page. And that is, what are the facts of the matter in question? So it's going to be each and every case on its own merits. And we need to look at the nature of the particular agreement. We need to look at the specifics of that agreement and of the facts surrounding it, and what the effect of the event a party is relying on the performance of an obligation under that. So I don't think we could say that COVID-19 is an easy way out. You're going to need to meet a very high standard in order to be able to apply it. So consider, for example, I'm going to give you a very illustrative example that is perhaps flawed, but it's just to illustrate the point that I'm trying to make here about impossibility and about the burden that you may need to take, that a party may need to take. So perhaps some of you may have noticed that for all the precautionary measures, there were always exceptions. So there were exceptions, let's say, to the curfews. If you looked at it, there were, you know, police were exempt, fire and rescue people were exempt, nurses and doctors and whatnot were exempt. Even and taxis were exempt from movement restrictions. So for example, if you had to execute something in person after a curfew, after the curfew time had come in. So you couldn't take your own car, but you could, in theory, take a taxi because taxis were exempt. Well, then there's no impossibility. You can't say that, oh, sorry, curfew's here, I can't make it on time at this point in time. You could get permission, take a taxi and go, even if you don't take your own car. So it's not like the precautionary measures are your ultimate way out. That's it, you know, Ijal Faraj, as we would say. No, it's you have to really show impossibility if you want this to work. And to give you an idea of how the courts are taking some of this stuff, because interestingly, we're already starting to see some people trying to say that COVID-19 is a force majeure event before the courts. And there is a judgment that I was very interested to see that came out on the 7th of June in Dubai. It's a rental case. Oh wow! I've just realized there's about 10 minutes to go, so I'm going to try and do this quickly. Right. So it's a rental case. It involved basically a company that was renting space from a landlord and the activity of this company was had to do with providing at-home medical care and other care for children, young children, and the elderly. Those are the two people who were most targeted by the precautionary measures. Nobody above 60, you can't touch them, and anybody under 12, you can't go anywhere. So that means their entire business model kaput in a day, and they had no idea how long it was going to take, and they lost all their business. Every single contract they had was canceled. The courts, in an extremely interesting decision, did not apply force majeure here for the breaking of the tenancy contract. Instead, what they relied on was Article 794 of the Civil Code, which deals with lease, which is probably one of the few instances I've seen of a judgment anywhere in the UAE that applies the Civil Code as opposed to, you know, the Abu Dhabi rent law or the Dubai rent law and so on. And that provision basically says that it's permissible for either of the contracting parties, for an unforeseen reason not connected to them, to require that the lease be terminated. But it required compensation in that instance. And there the court provided 3 months of compensation, 3 months of rent. But they didn't term it as rent, the equivalent of 3 months of rent as compensation for the termination of this agreement. Now, this was at the, let's say, first instance, so there's still the appeal to go. It'll be interesting to see how that one plays out as we go down. But that's a sense to give you an idea of how difficult it is to apply force majeure before the courts here, to rise to that level. So, as a quick example, can we apply force majeure in employment contracts? Now, if anyone attended the employment discussion a few weeks ago, then you'll already know the answers to this. But in very, very brief, you need to have a valid reason. So COVID-19 itself, like we said, not a valid reason. But imagine, you know, there are related factors. Your retail business was forced to close, like you lost all your business, like this particular company did. Well, are you entitled to let go of your employees? Arguably, it should be a valid reason, but it depends on how you present it. It's not about the reason itself. It's what you actually tell your employees, how you go about it that happens. What about your employees who are stuck abroad because they can't fly in? Well, it's arguable that there's a temporary impossibility for them to return. So you could rely on force majeure, but honestly, the safest bet is if you are in a position where you're forced to do this, then your termination under Article 117 is probably more appropriate. It would likely be a valid reason to say you're not able to perform your contract, your employment contract here because you're not in the country. What about contracts that are concluded post-COVID? Because everything we've talked about now it's fairly straightforward. Nobody understood that this was going to happen before all this, so that's fairly straightforward. But it's going to be very difficult for people who enter into a contract today, in the middle of all this, to argue that, hey, COVID-19 caused my problems down the line. If you are a business that's in Abu Dhabi and you need to deliver something to Dubai, well, arguably, you know that in this context today, if a restriction is lifted today that allows travel to Dubai and back, it might not be in place in a few days' time. It all depends on how this mess is going to progress. Hopefully, we're never going to see this again. And then obviously the UAE government has taken very stringent steps and they've done an extraordinary job getting us to where we are now. And hopefully we're not going to see another bounce back, but you never know. Today, in this context, it's arguably much more difficult for people to argue that, hey, there is a force majeure, and we could not have anticipated this. So what really can parties do to protect themselves in this context? If impossibility is extremely high, is very difficult to find, and even an onerous or oppressive burden is a very difficult standard to meet, then what can the parties do? Well, UAE law allows the parties to freely contract and can agree their own contractual terms, as long as those terms do not conflict with UAE law and public order and morals. So you can incorporate into your contract terms that can help you manage your legal and contractual risks. You can agree, for instance, a clause that allows you to increase your prices or to terminate the contract if certain types of events or certain events occur, even if they don't rise to the level of impossibility or onerous burden that we were talking about earlier. Let's say, for example, if prices of certain specific items rise by more than 30%, then you have the right to revisit the price, for example. Those are some of the things that you could put into your contract. You shouldn't forget, though, that if you're just saying we're going to put everything into a force majeure clause, and we're going to say anything and everything under the sun becomes a force majeure event, it's not really going to work that way. A lot of developers, for example, used to put into their contracts, and I believe some of them still do, that for sale of off-plan units, that delayed by a contract, which is a party that they are, by law at least, supervising and in control of, or for example, securing government permits to be able to build your building, well, those are force majeure events that allow them to kind of extend the duration. It's unlikely that the courts are going to determine that those are force majeure events, because those are things they should have anticipated in advance. And it will ultimately, regardless of what you put into your contract, the courts will decide whether an event constitutes a force majeure event or not. So if force majeure is not the easy way out, oh, sorry, we've already covered this, so I'm not going to go over this again. I'm going to move to this slide, because this is where you've got the majority of the stuff. And I personally think that aside from reevaluating force majeure clauses, a lot of people are going to need to reevaluate the force majeure clauses to make sure they're well thought out and well drafted and unambiguous to the extent possible, and that they meet the standards required under the law and so on. But maybe what's more important is to look at a material adverse change to circumstances clause, or a similar clause. There's no, you can call it what you will, but the basic idea is make sure you have a provision in there that allows you to modify your agreement, and you set the requirements and the mechanism to do so from today in the event there's a material adverse change to the circumstances because of precautionary measures or so on and so forth that have to be implemented as a result of this pandemic, or any other event that is, in our mind at least, something that may rise to the level of force majeure, even if it does not rise to the level of required under the law. Now, you need to acknowledge, if you do this, that you're not going to be able to catch everything in your contract. There's kind of, you do your best, you do the best you can in the circumstances, and at some point, there's something that has to be left to a higher power. You're never going to catch each and every possible circumstance. You do your best, and that's about it. And for the bits that you are not going to be able to catch, you might be able to cover it through insurance. Now, I know that in the UAE, this is kind of a budding field, insurance for, let's say, loss of business and so on and so forth, or default by clients in payment and so on and so forth. It's a very relatively young field, but there are options, I believe, available to you to help you manage that risk. And before we kind of close off, I think if I want to leave you with an idea here, it's that as parties and as members of a society, I don't think we should be focusing on force majeure really or looking for ways out of our contractual obligations. Obviously, for some parties, it's going to be extremely difficult. Sure, for some people, what I'm going to say here is not going to work. Obviously, but that goes back to one of the central ideas earlier. Each and every case needs to be looked at on its own individual merits. But as a broad strokes thing, obviously, I think we as a society need to kind of maybe we need to try and do better and kind of band together and support each other more. I think both parties or all parties to a contract are cognizant of the challenges that COVID-19 has brought to us, not just here in the UAE, but worldwide. Whether it's employers and employees or suppliers and clients and contractors and so on. So we need to try and not take the easy way out, and we need to try and be part of the solution and help those who are closest to us or those that work with us to kind of weather the storm and the difficulties that they're having. Some people are suffering from supply chain issues. Suppliers have shut down abroad and so on and so forth. And for them, there's going to be a lot of time for them to find somebody new who's able to deliver and so on and so forth. Point is, we're all connected, whether for better or for worse. And if we kind of use, like I've heard a lot of people try and do, is to say, hey, great, COVID-19 is an excuse for us not to pay or to squeeze our suppliers and tell them, well, take a cut and so on. Then if we do that, we're just basically going to be adding fuel to the fire, and we're going to be contributing one more step towards driving the economy to a breaking point. If we actively try and manage the relationships better and we try and say, okay, well, it's going to be difficult to do it this way. Let's find a solution outside of the court to try and help each other to manage this better, both of us. So that, yeah, okay, you take a hit, but I might take it a little bit as well, but we both come out of this intact, ultimately. And then we can do bigger and better things together once this mess is gone. I think if we have more of that, we'll be in a far better place. I would love to see a world where, there are issues like this that pop up in front of the courts less rather than more once the dust settles. Anyway, those are my personal thoughts on this. So, take it as it is. I hope you do kind of apologies if I've taken my lawyer hat off for a moment towards the end, but I do hope I've left you with a little bit of positivity, because I know this is not an easy topic for anyone. And with that, I think I'm going to turn it over to Q&A. I know I saw a couple of messages kind of jumping around.
Go ahead. Yeah, thank you, Ziad. Yeah, actually, we've received a couple of questions in this session, and there are as well some questions in the Arabic session, which I'm receiving on WhatsApp now. But first, I want to thank you on the nice conclusion and the nice ending, closing statement. And I believe that's the main purpose of having the Abu Dhabi Conciliation and Arbitration Center. It's a judicial podium where people can resolve their issues before going to courts. And at the end of the day, as you said, like, we're all connected. Let's try before, like, let's put the law on the side. Let's put the contracts on the side and have that mutual agreement on business terms as business partners. But I mean, life is not that straightforward, and that's why there are courts and there are laws in place to govern and manage the whole relationship. So I'm going to start with a question from, wait a second. So I'm going to start with a question from Muhammad. So what if the contract between both parties does not have the force majeure clause specifically, that is an office rent contract? Can a commercial tenant terminate the contract due to pandemic and avoid to pay the early termination penalty?
Yeah, I think, okay, so there are two aspects there that I'll unpack. The first one is it doesn't really matter if you have a force majeure clause in your contract or not. Force majeure is something that if it applies, the courts will decide if there's a dispute. So whether it's there or not isn't really going to make a bit of a difference. It does help if you have one, because you might agree on, let's say, you're going to give yourselves a period of time where everything stops. You stop the clock and you wait to see if the force majeure event is going to subside. And then if the period of time that you've agreed, let's say, isn't enough to cure, to have the FM event pass, then you can agree to terminate the contract or what have you. So that's on one side. So it doesn't really matter if you have one. If on the flip side, saying, I think the example I gave you of the judgment in Dubai is quite illustrative of the point that I don't really believe that the COVID-19 pandemic is going to allow people to get out of their tenancy obligations, unless, you know, like I gave you this very real example of a company that was severely affected by the precautionary measures put into place, because the two age bands that they work with were the ones that were targeted by the measures more so than other age bands. So the above 60 and the under 12. And even for them, it wasn't considered force majeure in that particular judgment, and they still had to pay, you know, a couple of months of compensation to the tenant. I think for other businesses, retail businesses and whatnot, you have maybe room, because like I said, in the current context, everybody is kind of going to be a little bit more understanding, or I would hope that they are. If push comes to shove and you have to go to court, it's going to be an uphill slog to kind of prove that you're going to have to show that your business was extremely affected. You're going to need to build it on the not on the fact that people chose to stay home and not spend money, but on the impact that you suffered because of specific actions that were completely outside of your control, taken by, let's say, government or whatnot. Like certain area, like for example, if you are a coffee shop in a I don't know. I'm wary of giving you an example, because if I give it to you, it might not actually. Even there, the courts might not accept it to be something worthwhile. But you know, if you're shut down completely because of a precautionary measure, you can't do any business whatsoever, then you have a better chance than otherwise to argue that there's force majeure. But it's going to be an uphill slog, in my view. Because you need to, force majeure needs to be linked with impossibility. Sorry, yeah.
Yeah, but from what I've got from the presentations we had and from all our previous discussion, it was an hour and a half yesterday until late night. So it's almost impossible. as it says, like there should be an impossible event for it to be triggered. But I mean, it could happen. I know this is not the case in the UAE. This is a global case. It's like everywhere probably in the globe. And you correct me if I'm wrong. It has not been covered as an event, has not been considered a force majeure event. But this I mean, this is a good example for us to plan for the future, as you mentioned in the keynotes, like other alternative ways to protect our rights in the agreement. Things that, I mean, with the support of expert lawyers, businesses and people can draft, like you mentioned in the keynote. I'm gonna go to another question from Shadi. Shadi is a close friend. I got you, Shadi. He's in construction, and he's asking if he can use force majeure as leverage to claim the time and cost impact. I know you've covered this, but very quickly, just to give a clear answer to Shadi.
Well, hi, Shadi. I think you're going to need to show how you were impacted because of COVID-19. And I don't think COVID-19 itself is going to be what will allow you to rely on that. It's going to have to be something else, because the pandemic itself, well, you know, construction particularly, for example, wasn't really affected. They were one of the exempt items in terms of kind of continuing work, except in very specific circumstances. So it's going to be, you're going to have to look at your specific circumstances, what you can rely on exactly to be able to go there. But I don't think it's going to be, personally, I think it's going to be a bit difficult to rise to force majeure. And bear in mind that if you say force majeure, it means you are wanting to cancel the contract, which from what you're asking, doesn't seem like it's the case. What you want is something that is a foreign event that's oppressive or foreign to you, that you have no control over, that doesn't rise necessarily to the event, to the level of force majeure, but still allows you to claim some extra funds. That would bring you to the Article 249 number. Yeah, 249, I think it is, about the overly oppressive nature of an event. And unless you have something specific in your contract that mentions where and when you can ask for additional costs, it might be difficult for you to ask for those extra costs. I think contractors, they've kind of tackled a lot of this already, and their clauses, their contracts tend to be quite voluminous, and they tackle quite a lot of potential things that go wrong. So you may have a chance, but not through force majeure, in my view, directly at least.
Thank you, Ziad. We're receiving like many questions, honestly, and I'm gonna like, if you try to go as quickly as possible on, I mean, just to answer as much as possible.
Yeah.
We still have 2 minutes to go. We're happy to
Yep.
extend it for a couple of extra minutes, but I know you don't mind, Ziad.
Yeah.
So let's go as quick as possible on the rest of the questions. So Ahmed is asking why most of the articles covered are under civil and not commercial law.
It's a fair point. It's I figured because we have very limited time, I figured it would be easier to kind of go with the source. The civil code is where you'll find the basic ideas, and they'll apply to whether it's commercial contracts or otherwise. And then, you know, I felt it was faster because we've only got 40 minutes to go over everything.
Yeah. Okay, so this is something referred to the presentation. I thought it's something referred to the court. So from Sameh, what if the force majeure has a time limit? So if I don't terminate under the force majeure, let's say within 10 days, I lose the opportunity to do so.
That's an interesting one. I think there's an obligation on the party that has to that wants to rely on force majeure. There should be an obligation to kind of bring that up at the earliest possible chance. I think it has to be reasonable. The courts ultimately will be the arbiters of whether there's a force majeure event and whether a party can rely on it. So you could argue that they lost their chance if it's within 10 days, but you don't necessarily know what the impact is going to be of something within that period of time. So I would say it's touch and go, depends on a lot of factors. I'd say, you know, if we were in front of the courts in the UAE, those 10 days will probably be a bit tight. You don't lose your right you should not lose your right because of this. We'll have to look at other aspects of your contract as well to kind of help bolster that argument. But otherwise, if you have agreed on something, there's also a chance the courts might say, well, you agreed you're going to have to abide by that timeline. We'll have to, an interesting one, will have to be, if things go pear-shaped, I guess there's only one way to find out. Yeah. And that's through the courts. So, it's another question. Sorry, it's not much more helpful than that, this answer.
Yeah,
here.
No worries. There are a couple of questions that you've already answered, but I'm going to raise them just in case you have something additional to add. So Bijou is asking, can I cancel my residential or commercial lease contracts on force majeure? And another question from a fan. So based on the late verdicts given in recent months, what's, in your opinion, been the mood in the courts, which you've already mentioned, and we've already discussed through the whole session. But if you have anything extra you want to add on those, would be great.
Yeah, well, to be fair, I've only seen this one judgment yet where somebody's trying to push that argument. So I'm sure we're going to start seeing more of those as time goes. But there's always going to be a lag because as you know, some of the courts were shut down for a while. They were gradually picking up, of course, and gaining speed again, whatever lost time there was. So there's going to be a little lag before we know what the answers are going to be coming or the position that the courts are taking. But I think it's fairly clear from this and from earlier examples that force majeure is going to be interpreted in a very narrow and restrictive manner. It doesn't stop a party from trying to claim it. And if they are able to prove force majeure, then obviously they may be able to terminate or cancel their contracts, whether it is lease contracts or otherwise. I would view, unless you have very strong evidence to kind of support that contention, unlikely to fly.
Okay.
Yeah. Yep.
I'm going to take 2 more questions. Yeah, please go ahead. Sorry.
There is one question here from a gentleman called Muhammad, who was asking about whether they can use force majeure to amend the contract. So that's why I was referring to Article 249 of the Civil Code earlier. which allows a party to, if they can show that that an external event or cause was extremely burdensome and oppressive to them, that the courts can revisit the contract and try and balance the contract again. And that would necessarily entail, balancing payment obligations or increasing the value of the contract and whatnot. But like in the example I gave you, the courts seem to have been interpreting this extremely narrowly, and the level of burden needed to reach or the standard really to apply seems to be extremely high. So unless you have something else, another clause in your contract that would allow you to seek compensation, and that's something else. Now, if it stops you, if the events have stopped you from proceeding with the work for a reason or other, yeah, you should be in a position to apply for an extension of time or whatnot. We'll have to look at your specific circumstances. You'll have to look at everything in your hand and see if you are able to base it on something and apply it to your contract or the law. It's not just straightforward, hey, force majeure, we amend the contract. It doesn't work that way.
Okay, I'm gonna take 3 more questions, Ziad, and there are 2 questions which I'm gonna refer to you by email from Ronald and from Aaron. I believe it's gonna be lengthy to respond to those now, and they're very specific to the cases. If you don't mind, Ronald and Aaron, we got your email addresses, and we're gonna send your questions directly to Ziad. For now, I'm gonna take 3 more questions, and we're already like 4 minutes past the time. So very quickly, Ziad, Riyad is asking, is there generally a provision in contracts that will entitle a vendor or service provider to compensation if discharging his obligation is not impossible, but rather more costly and cumbersome than envisaged?
I think you could agree to put something like that in the contract, that you would be entitled to an additional cost or additional fee for proceeding and completing performance. If it goes beyond a certain level that you both agree is reasonable, certainly that was kind of the idea behind the material adverse change clause I was suggesting that some parties kind of try and look at. Some contracts already contain for some clauses of this nature, but perhaps people are going to start revisiting them in the wake of all this.
Okay. There are 2 questions which I'm going to take from Arabic, so I'm going to translate. So one of them, and help me with the technical terms. So did the prosecutor differentiate between القوة القاهرة والظرف الطارئ, so force majeure and exceptional circumstances? I don't know what's the technical term.
Yep.
So هل فرق المشرع بين القوة القاهرة والظروف الطارئ?
Yes, the exceptional circumstances and force majeure. Yes, it's clear that the law has made a distinction between the two. I believe there's one article of law that actually kind of illustrates the point. I'm going to try and find it here. I've written out here. There you go. So 287, you've got a loss arising out of an extraneous cause, such as a natural disaster, unavoidable accident, or force majeure, or act of a third party, or act of the person suffering loss. So you've got here, and you've got something here expressly mentioning force majeure as something separate to an external event or an external cause that is unforeseen, and so on and so forth. Although the definitions sometimes are very similar, there's clearly in the minds of the drafter a distinction between the two items. So I hope that's helpful. Yeah, the definitions are somewhat similar, but not fully.
Yeah. Last question, Ziad, from Asimla. That's in Arabic as well. So excuse me if I spelled the name wrong. What are the legalities of the penalties that have been imposed on contractors due to delay in delivery? And at the same time, can the contractors request for an amendment to the contractual contract duration to deliver the project?
Sorry, could you?
I believe you have access to the Arabic wording, exact wording, Ziad. But I mean, that's it in a nutshell. No worries, no worries. It's basically what are the legalities of the penalties imposed on contractors due to delay in delivery, and at the same time, if they are allowed to amend their contracts in terms of the duration to provide to deliver the project.
Yeah, I think if amending the contract, you'll have to see if your contract allows you to do so and what the circumstances what the circumstances are that would allow you to amend the price of the contract. In terms of whether or not you would be entitled to an extension of time, if you're able to show something prevented you from proceeding with the work for a reason that you had no control over, that was foreign to you, and so on and so forth, this external reason, then whether you have something in your contract or not, it's arguable that you should be in a position to ask for it, the extension, because it's something that you had no control over and you couldn't mitigate that risk. So you shouldn't be responsible for it. So you shouldn't have to kind of, you should be granted an extension for that. You may have a series of legal arguments at the very least that you can stand on to ask for that extension of time. The revision to the contract price will very much depend on your contract itself, most likely, and on the value of your contract and the extra costs incurred if you were to be able to kind of ramp up your schedule so that you kind of meet the timeline that was initially anticipated. Yeah.
I believe we're done. Apologies for like extra 9 minutes, but I'm certain that you're all excited on this. We already covered the majority of the questions, more than 90% the of it. Any final words before I close from my end?
Yeah, thank you, Tom. I hope everybody enjoyed this or found it informative at the very least. I'm sorry if some of you are sweating now. That wasn't the intent. It's not an easy time for anyone, and this is one of the reasons the chamber has put these seminars together, to try and give people access to information so that they're better informed and therefore better able to act and prevent or mitigate, as the case may be. And if you need anything, we're here to help, both the chamber and us. Thanks very much again.
Thank you, Ziad, for your time. As usual, so interesting having the sessions. We still have 2 sessions with you towards the end of August. I'm looking forward for it. For all our audience, like there are many attendees asking if they're going to get the presentation. I believe the answer is yes, Ziad. You're happy to share this, so we can share this with the audience. Yeah. Yep. So you'll get it on your email after the event. We're done for the day. We expect you as well and look forward for you to join our next session on Tuesday with EY on protecting the business by protecting the family. So until then, stay safe and have a good day. Thank you, Ziad, and thank you, audience.
Thanks, everybody. Bye.
Bye.